Marsha Rucker joins us from the U.S. Equal Opportunity Commission. Marsha is a regional attorney and works out of the Birmingham District Office. Marsha began her career with the Commission as a trial attorney in 2008 and became regional attorney in 2016. Welcome, Marsha Rucker.
Good morning, everyone. Can you all hear me? Can somebody signal that they can hear me? I ask, first of all, that you bear with me. I've done several of these Zoom presentations, but it's always a work in progress. I, like many of you, have sat out there in virtual wonderland, and it is an adjustment to get used to it. But we are where we are, and so I would just like to say, first of all, thank you for the opportunity to speak with you. What I'll do today is I'll kind of give an overview of who the EEOC is, and I'll talk about some of our initiatives. Then, of course, I'll talk about the ADA in the context of it being the 30th anniversary. And then I'll talk about some notable cases that came out in the last 2 years since 19. And then I'll talk about the future of the ADA in the context of COVID. COVID is the hot topic at present, and I thought it was important to speak about COVID. So first of all, with respect to the EEOC, we're a bipartisan commission, and we enforce federal anti-employment discrimination laws, including the Americans with Disabilities Act and Rehabilitation Act, Title VII of the Civil Rights Act of 1964, which has been amended, the Age Discrimination and Employment Act, and the Genetic Information Non-Discrimination Act. That's our newest act, which went into effect in 2009. With respect to the ADA, of course, Title I of the ADA applies to private employers with more than 15 employees. With respect to the commission, again, I mentioned at the top, we're a bipartisan commission, and that's comprised of 5 commissioners. Our chair is Janet Dillon, and we're fully functional, meaning that we have a full accompaniment of all 5 commissioners. 3 of our commissioners joined us within the last month or so, and those would be Keith Sonderling, Andrea Lucas, and Jocelyn Samuels. Just some by way of litigation statistics, in 2019, we filed over 144 merit lawsuits against private employers. As far as 2020, our statistics are raw. It doesn't look like we filed quite as many, but we've had substantial more recovery in terms of money and injunctive relief. And given that we're a pretty small agency, I think people are amazed to know that the EEOC only has about 2,500 employees throughout the country. Of course, we have 15 districts in which these employees are spread throughout those districts, and the different divisions within the commission, such as Office of Legal Counsel and Office of General Counsel, which I'm a part of as a regional attorney. And so, you know, we have limited resources. And so it's important for us, and it's been the practice over the last years or so, to develop a strategic enforcement plan. And every 4 years, that plan changes. And at present, our strategic enforcement plan, the following categories are in effect. We have eliminating barriers in recruitment and hiring, protecting vulnerable workers and combating systemic harassment, emerging issues such as LGBT issues and flexible leave policies, and access to the legal system. And so that's kind of an overview of the EEOC. And so what I'd like to turn our attention to, in the slide is current, is the ADA. I kind of would like to give you a little bit of a background regarding the ADA. One thing of note about me, although I'm a lawyer, Actually, I was a history major in college, and so I always like to see how things evolve. What is the history behind the act? And I think the preceding speaker did a wonderful job in giving you that kind of historical context, but I'd like to add just a few tidbits as well. And so, as stated, we're celebrating the 30th anniversary of the ADA, which was passed on July 26, 2020. On that day, more than 3 decades now, President George H.W. Bush declared, "Let the shameful wall of exclusion finally come tumbling down." And so, again, the EOC enforces anti-discrimination and employment statutes and laws. But so the lead up to the ADA, there were many years of a working history. And so, just to give some historical context, back in 1927, most commentators would point to the case Buck versus Bell as a pivotal point in the ADA movement. In this case, the Supreme Court allowed those with disabilities and those with perceived disabilities to be forcibly sterilized, declaring that 3 generations of imbeciles are enough. Justice Holmes found that it was better for all the world that those disabilities be wiped out. In fact, so awful was that decision that the Nazis relied on Buck at Nuremberg to support their use of eugenics and forced sterilization. And so we can see that from 27 to 1990, what is that, about 60 years, there were advancements along the way, but it took a long time for folks to realize that just because persons have disabilities, that doesn't mean that they shouldn't be fully functional members of our working society. And so what we see at the time when the act was passed, I think it's notable that was 2 years following a national election such as we're in the throes of now. For example, in the summer of 1988, Governor Michael Dukakis was running against then Vice President George H.W. Bush in the pending presidential election and was the subject of rumors regarding psychiatric treatment. A reporter asked then President Ronald Reagan if he thought Dukakis' refusal to provide his medical records was hurting his campaign. President Reagan remarked, "Look, I'm not going to pick on an invalid." And so that kind of gives you even the run up to the 90s, kind of what the thought was regarding persons with disabilities. And so as we've discussed, shortly thereafter, we all know the outcome of that 1988 election. George H.W. Bush was elected, and one of his notable achievements in office was the passage of the ADA. And so after his inauguration, President Bush charged Attorney General Richard Thornburgh with the duty of getting major disability discrimination legislation passed. And so we just simply don't know, but there's conjecture out there whether Bush's urging was the result of President Reagan's comments or compassions for his family members with medical conditions. We do know that President Bush was instrumental in passing and helping ensure that the ADA was passed. Some observers have noted that the ADA is probably the most sweeping piece of civil rights legislation possibly in the history of our country and a model for the world. And so if you could advance to the next slide. And so you see here, I have highlighted a case, Nassau County versus Arlene, and I'm going to return to that case. As the notes on the screen suggest, Arlene provided the underpinnings for what would later be the 2008 amendments to the ADA. And so, yes, if we can just hold current at this slide, I'm going to kind of review what the significance of those amendments were, what material changes occurred as a result of the passage of this particular amendment. And then I'm going to go back to Arlene, because I think, again, Arlene is instructive because it did provide the underpinnings for the amendments, but it's instructive and has utility for what we're all facing now, being in the throes of the COVID-19 pandemic. So again, with respect to the 2008 amendments, following in his father's footsteps, President George W. Bush signed the ADA Amendments Act of 2008 into law on September 25th, 2008, and they went into effect the following January 1st, 2009. And the ADA made a significant number of changes. And just for a second, indulge me, I kind of like to do a slowdown and highlight what those significant changes are, because they have real world implications for how we at the EOC look at ADA charges of discrimination. First, Congress considered supplementing the definition of disability by adding language such as materially restricts to further explain the degree of disability reflected in the term substantially limits. The ADA defines disability as a physical or mental impairment that substantially limits one or more of the major life activities of such an individual, a record of such an impairment, or being regarded as having such an impairment. However, Congress ultimately decided not to change the actual definition of disability, but to clarify its original intent. And so what Congress did in effect, and I, again, as a historian of sorts, I find it interesting that when it passed the amendments, it actually expanded terms and even considered our guidance, meaning the EOC, to be somewhat conservative, and actually expanded what the EOC's position was prior to the passage of the amendments. Second, Congress explained that the definition of major life activity was expanded to include major bodily functions. Major bodily functions include, but are not limited to, immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. Prior to the passage of the amendment, such functions were not covered by the ADA, even though states such as New York included bodily functions within their state statutory definitions of disability. Third, Congress defined impairment as something that substantially limits one major life activity. Prior to the ADA, such functions were inconsistently covered by the ADA because Congress stated that the term substantially limits, as construed consistently with the findings and purpose of legislation, established an appropriate functionality test for determining whether a person, in fact, was a person with a disability. Congress noted that functionality tests included an evaluation of condition, duration, and manner of the individual's disease on major life activities as compared to most other abilities to perform those tasks. Fourth, and I think this is key, Congress required that impairments be considered in their unmitigated state when assessing whether they fall within the definition of disability. If you could, you can advance to the next slide because we're going to talk about Sutton. And so prior to the passage of the amendment, there were several cases on record in which it was determined that, you know, if you had a disability and it could be corrected, then for purposes of you don't meet the definition of disability. This, of course, is set forth on the slide, was codified in Sutton versus United Airlines, and the following in companion case, Toyota Manufacturing versus William. And so under these cases, the definition of a disability was severely limited, and again, took into consideration whether or not the condition could be mitigated. And so what you had, interestingly enough, were folks who were proactive in getting treatment for their disability, weren't covered under the statute, but folks maybe who were dilatory were. So that's an interesting juxtapose that the amendments corrected. Fifth, Congress clarified that an impairment that is episodic or in remission, such as epilepsy or cancer, is a disability if it would substantially limit a major life activity when active. This provision was based on Congress's intent that courts consider the total effect of the impairment rather than whether the impairment can be controlled with medication or treatment. 6, Congress broadened the regarded as prong of the disability definition. An employee, after the passage of the amendment, need not demonstrate that the employer regarded him or her as substantially limited in one or more of the major life activities. Instead, the focus now was whether or not, or the focus included or was expanded to include whether or not the employee was regarded as disabled if she suffered or he suffered an adverse employment action under the ADA. However, Congress provided an exception to this prong of the definition by excluding those conditions that were transitory and minor in nature, such as the diseases that were contemplated to last less than 6 months. The Senate noted that this limitation was necessary under the regarded as prong because these individuals did not pass the functionality test like individuals under the first or second prong of the definition of disability. The provisions of the ADA that the Congress didn't tinker with or change are equally significant as those that were changed. Congress did not change the following statutory terms: reasonable accommodation, undue hardship, essential function, qualified individual, or direct threat. These definitions and the case law discussing them remain unaltered and continue to serve as the standard, such that employers are still able to raise and assert them as affirmative defenses. For example, they can raise direct threat or otherwise qualify as a definition. And so I throw this all out because as we discuss the evolution of the ADA in the context of evolving case law, it's important again to remember that the 2008 amendments were a game changer, and also that, however, that certain key definitions didn't change. And so where maybe the focus prior to the amendments was on determining whether someone was disability, now in case law, we see those other issues, those affirmative defenses in particular, become more significant. If you could advance the next slide. And so just for your own edification, I'm not going to go through all of these regulations, but I did try to provide you with our most up-to-date regulations with regard to the ADA. In total or in sum, these regulations are found in the CFR, and we know that every year updates are made. And so I suggest if you have discrete technical questions that you refer to our guidance, and you can refer to the appropriate CFR sections. So if you can advance the slide from there. And again, I just have provided you with a summary of why Congress amended the ADA. In some, Congress, if you remember nothing else from the presentation, Congress amended the ADA to make it more broad and more expansive and more inclusive. Please advance to the next slide. And so again, for your own edification, I provided the definition of disability. I'm not going to repeat that. You can advance the slide. And so again, another summary of what we just went over. Advance the slide, please. Again, further technical guidance. You can advance the slide. Please advance. You can advance. You can advance. And so I'm going to leave the, please let the slide hold there for me. And so what I'd like to do is to go back to the earlier slide. You don't have to advance the slide back to Arlene, but I'd like to talk about this case. I find this case fascinating given where we are in terms of COVID. Not only does, in summary, does Arlene, again, provide the underpinnings for the amendments, it also gives us a roadmap or precedent as to how we should interpret, what's going on in the context of COVID. So let me go back and give a brief explanation of the case, the Supreme Court case, the School Board of Nassau County versus Arlene. This was a case decided in 1987, so it was decided several years before not just the amendment, but the actual ADA, which of course, again, was came into effect in 1990. And so in this Supreme Court case, we see where the Supreme Court ruled that a school teacher infected with the contagious disease of tuberculosis was, or in their estimation, met the definition of being a handicapped person. Again, I'm just reading or setting forth what was said in the case law. I know that the correct term is a person with a disability, but again, we're talking about a ruling from well over 30 years ago. And so again, the Supreme Court ruled that the school teacher was in fact a person with a disability given the nature of tuberculosis. In terms of the facts, Jean Arlene taught elementary school for 13 years in the state of New York, during which time she suffered 3 relapses of tuberculosis within a 2-year period. And the school board acknowledged in their termination that, hey, we're not faulting you for having tuberculosis, but you present too much of a danger to our staff and children to continue working in the workplace. Does this sound good to anyone? And so when the case wound its way from the Second Circuit up to the Supreme Court, the Supreme Court, considered the definition of a handicapped individual as set forth in Section 504. And the court recognized that the definition encompasses any person who has a physical or mental impairment which substantially limits one or more of such person's major life activities, has a record of such impairment, or is regarded as having such an impairment. The court recognized Congress's intent to provide broad protection against discrimination through Section 504. The court also considered the regulations promulgated by the Department of Health and Human Services, which drafted legislation or regulations under the watchful eye of Congress. These regulations define 2 terms that the court deemed significant to the question at bar. The first was physical impairment, which is defined by any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more of the following body systems: neurological, musculoskeletal, special sense organs, respiratory, including speech organs, cardiovascular, reproductive, digestive, hemic, lymphatic, skin, and endocrine. The second definition of significant importance was major life activities, which we define as the ability to care for oneself, performing manual tasks such as walking, seeing, hearing, and speaking. The Supreme Court considered the question of whether Arlene was handicapped within the statutory definition. The court, in its final analysis, held tuberculosis had impaired Arlene's respiratory system, and that this impairment was serious enough to require hospitalization, a fact more than sufficient to establish that one or more of her major life activities was substantially limited by her impairment. The court held that her hospitalization for tuberculosis established that she had a record of impairment. And so, again, I don't think that the school board quibbled with whether or not she was disabled. Clearly, she was disabled. Again, their contention or their defense was it was a direct threat. I mean, she had a communicable disease. This presented a hazard or potential hazard for its employees and for the children. And for that reason, the direct threat, the school board argued that they were within their right to terminate Ms. Arlene. And so what's interesting to note is that the court actually punted on the issue of whether or not Ms. Arlene's condition presented a direct threat, but it did give some advice when it remanded it back to the district court. The court told the district court to consider the following factors when determining whether or not Ms. Arlene's condition presented as a direct threat. For example, it adapted the position of the American Medical Association, which expressed a position in its amicus brief. And so the court directed the lower court to consider the nature of the risk, how the disease, for example, is transmitted, the duration of the risk, how long is the person infectious, the severity of the risk, what is the potential harm to third parties, and the probability, and for the probability of whether or not the disease will be transmitted. And in addition, the court stated that courts should consider whether an employee could make a reasonable accommodation for such an employee. And so when it went back to the district court held that Ms. Arlene was, in fact, based upon those factors I just cited to, was an otherwise qualified person. The court considered carefully each criteria as set forth by the Supreme Court and came to the conclusion that the school board didn't terminate Ms. Arlene based upon a direct threat, but instead based upon myths and fears, and that the court concluded that Ms. Arlene was terminated based upon the employer regarding her or her being regarded as disabled. The court explained its rationale with respect to whether or not she was a direct threat in the following way. By amending the definition of handicapped individual to include not only those who are actually physically impaired, but also those who are regarded as impaired and who, as a result, are substantially limited in a major life activity. Congress acknowledged that society's accumulated myths and fears about disability and disease are as handicapping as are the physical limitations that flow from actual impairment. And so, as to the specific facts, the court found that, it was interesting that here we have Ms. Arlene, who had a family, she had children with whom she lived in the house, and none of them were affected or contracted tuberculosis and were otherwise healthy. That fact, along with several others, went into their conclusion that Miss Arlene didn't present as a direct threat to the employer. And so, again, I like that case because I think it does give us a roadmap to discuss COVID. But before I discuss COVID, I do want to alert you that in real world applications, the EEOC has a wealth of information on its website, including all kinds of technical assistance documents. Throughout this presentation, including here and at the end, I will provide some information with regard to that technical guidance. But I do want to highlight some technical guidance that was recently issued with respect to the use of codeine, oxycodone, and other opioids. We've issued some guidance in that respect, and also directed to healthcare workers or other advocates who can help fashion reasonable accommodation requests so that folks can continue in the workforce. If you could advance the next slide. And so what I've turned this portion of the discussion is a round robin of circuit case law. Case law, I think under any other, I think with respect to the ADA as compared to other statutes we enforce, I've seen evolution of ever-changing evolution of case law. I think this is one area of law, the ADA and its interpretation, that is constantly evolving more so than the other statutes that we enforce. And again, as we move to our discussion with COVID, it's my prediction that will continue to be the case. And so the first case that I'd like to talk about is a case called Fisher versus Nissan America. And so I think that this case is critical. As you see, it arises out of the Sixth Circuit and was decided in 2020. I think the district court decision was out of Wisconsin, and it involved an auto worker who was a good employee, had over a 10 plus year history of being a stellar employee. He always received positive employee evaluations, but he had failing health. I believe he was diabetic, and then he had resulting renal kidney failure, and in fact had a kidney transplant. And as his condition began to worsen, he had requested several reasonable accommodations, and the employer acquiesced. For example, being able to take his insulin or have a refrigerator close by. But after he attempted to return to work after a kidney transplant, he requested to be put into a position that was less taxing and less demanding. We often say in the ADA, when an employee requests a reasonable accommodation, of course, they don't have to use magic words. And in fact, Mr. Fisher didn't use magic words, but he said, hey, I'm coming off this kidney transplant. The job that I'm currently in, it's just too physically demanding. I know that, for example, there's a rivet inspector position that you often put folks returning from workers' comp leave, and so I'm saying, because I'm requesting, because I want to keep my job, if you could put me in that position. Well, what we learned in this case is that the employer shut down the interactive process. Its position was, hey, we've accommodated you. We're not going to offer your most recent request. We're not going to honor that. And so Mr. Fisher was unable to continue in his employ with Nissan. And so the Sixth Circuit found that, you can't shut down the process. reasonable accommodations. Just because one was granted, that doesn't mean opportunities for other reasonable accommodations aren't foreclosed. At every juncture, when a reasonable accommodation is requested, again, you don't have to use magic words, and the employer has a duty to engage in the interactive process. And the only detriment to providing the reasonable accommodation would be, for example, if it causes an undue burden, or in effect, it wouldn't help the person be successful in their job. Okay, you can advance to the next slide. When I was reviewing this case, I don't mean to be flip or to chuckle, but you know, again, if the prior case taught us that you have a duty to engage in the interactive process, this case suggests that even there is a limit. And in this case, it involved Mr. Clark, who was the plaintiff in this case, is a person with a disability. There was no dispute about that. He was diabetic, and he was a person L, I think, director or supervisor. And so what Champion is it's a uniform service provider for folks who work in the janitorial industry. And so initially, Mr. Clark, he had requested conditions unrelated to his diabetes. For example, he wanted to grow a beard, or at least the records suggest, or that he wanted to grow a beard. And so he then he asked his employer, well, can I have an accommodation to grow a beard because I have dry skin? And of course, we know dry skin, well, maybe there is an argument to make, but generally speaking, dry skin doesn't fall within the definition of a disability. And then, but seriously, in relation to his diabetes, he did make other requests, such as he wanted a refrigerator to store his insulin, and he also wanted the possibility not to be penalized for going to doctor's visits. And again, in this context, we see the employer complying with his request for accommodation. However, the tipping point in this case is that the employer had a policy across the board that their employees needed to be alert on the job and not fall asleep. Well, lo and behold, Mr. Clark, he was caught asleep in his office at least on 2 occasions. The first occasion, basically, he denied that he was asleep, and the employer gave him a free pass based upon their own investigation requirements. And in this context, the employer had in place a policy where if somebody was going to be terminated for not being alert, that there had to be 2 witness statements and pictures. And so they didn't have that the first instance. Well, the second instance, they did. Mr. Clark went into his office, he locked the door. Somebody was able to open the door and take a picture of him sleeping, and there were 2 witnesses who corroborated this. Well, Mr. Clark asserted as I would say a defense, that he didn't pose a safety risk. He couldn't deny that he was in violation of this policy, but in essence, his defense, and I use that loosely in air quotes, was, okay, I don't have a safety sensitive position. I'm just, logging information into the computer and making sure that people have copies of our policies and processing payroll. And so I'm not in a safety sensitive position. It shouldn't matter that I sleep on the job. Well, the court didn't buy that. As the slide states, the court held that he wasn't a qualified person with a disability, even though he was not in a safety position, because employers can have requirements for the job, and case law is clear that for most positions, being alert and awake is an essential function of the job. And again, the greater point to come from this case is that, as with the other case, employees can request ongoing reasonable accommodations. However, they have to be related to their disability, and they have to render the person able to perform the essential functions of the job. Okay, if we can go to the next slide. And so I'm not going to go over the holding in this case. It is extremely new, but their employers are required, and it's longstanding precedent to provide accommodations in the workplace for those with hearing impairments to fully participate. In this case, it was deemed that the employer had met its requirement because it did have lights on machinery, and it had technology available for persons to obtain important information via alternative means. However, I would like to point your attention to the 3 cases I have highlighted that are recent EEOC decisions. And you can go to our newsroom web portion of our website to read a full detail about these cases. But I would like to point your attention to that there is a typographical error in the final case reference, the FedEx Ground case. We didn't recover $33 million. We only recovered $3.3 million, and that was on behalf of a class of 229 hearing impaired individuals. And so, again, I encourage that you visit our website. If you could advance the next slide. And so this is another case. It's not a lawsuit. Actually, it's an administrative charge where we found cause and we had a public conciliation. So there was no lawsuit filed, but there was an agreement where the commission could publicize that this conciliation took place. And this is a key decision. In this case, not decision rather, what the parties were able to agree to is that accessibility, it has to be in all forums, and technology, you have to consider technology. In this case, as we see the respondent Dish Network in their administration of taking employment applications online, they had a question that said, are you available for all shifts? And so if you said no, then you are automatically disqualified. And so this, under the ADA, this really had a significant impact, and it shut out potential employees who maybe had epilepsy. There's also a consideration whether or not it shut off folks who had caregiving responsibilities. But again, the conciliation was limited to the issue of disability. And so the EEOC was able to negotiate agreement where Dish removed this question. And there was also a significant monetary award as this was a nationwide class of individuals. And so if you can advance to the next slide. Again, even though this case, Belinsky versus American Airlines, was just decided in a little over a year ago, this case is key, and it does acknowledge that there's not always a one size that fits all approach, particularly given the evolution and advances in technology. Uh, what may seem reasonable today may not seem reasonable. And again, the fact that this was decided pre-COVID, I'm certain as cases continue to evolve, telework in particular may be seen for most employees as a reasonable accommodation. In this particular case, you had a plaintiff who job responsibilities changed for a long period of time. She had a accommodation where she could work remotely, but once the airline was restructured, they said her particular position would become more collaborative in nature, given the consolidation of operations with the airlines. And so what this case holds, of course, is though that even where a previous accommodation was made, if it's no longer feasible for the employer, if the employer can show an undue hardship, the employer in essence is off the hook. Next slide. And so all these cases I think are goodies. As you can imagine, how many cases are decided in any given year, and I've just tried to highlight several of importance, but I think this case is, I call this, well, it is the massage envy case. Remember when Ebola was all the rage as far as pandemic conditions? Well, in this particular case, there was an employee of Massage Envy who wanted to visit her sister in Africa. And initially she was given approval to take the time off to visit her sister. But once a principal in the company learned that she was going to a country in Africa, he told her that if you go, you will be terminated. And she in fact went. Then when she, of course, came back, she was terminated, and she filed a charge with the EOC. We found cause, we filed suit. However, in the end, the action was dismissed. The court ruled that our complaint was futile because she didn't meet the definition of being a person with a disability because she hadn't contracted Ebola. She wasn't even a person who was regarded as, because the employer, that was his concern, that she would contract Ebola. And so I think that this case is unique because it, at least in our circuit, the 11th Circuit, it sets some clear guidelines of what regarded as means. If you can advance to the next slide, I know that we're running out of time, and so I'll just try to speed through COVID. I mean, COVID, of course, is the topic of the day. You can read the slide, the information. COVID is a pandemic. It's probably one of 4 pandemics that has hit the American shores in the last 120 years or so. And so if you can advance the slide, under the ADA protects applicants and employees from disability discrimination. And so what we see here is some guidance is, with respect to employees, that employers can't just willy-nilly ask or assume you have COVID. They have to have a reasonable basis to require an employee to be tested or to conduct a medical inquiry, and the employer is on the hook for paying for that. And then with respect to the application of the ADA prohibits covered employers from excluding employees unless there's a direct threat. Interesting enough, the CDC has issued guidance which employers can rely on that says COVID does present as a direct threat. However, there's still the requirement that employers should consider reasonable accommodations. As our previous speaker indicated, COVID, we don't simply know what all the full and lasting ramifications are concerning COVID. We do know that there's some individuals who do unfortunately have issues with major life activities and also major bodily functions as a result of COVID. You can advance to the next slide. And so I talked about disability-related inquiries in the context of COVID. You can perform a medical evaluation at post-offer that doesn't change. But with respect to during employment, again, it is incumbent upon the employer to have a good faith belief that the person may have COVID. And this belief must be based on objective evidence and reasonably available to the employer. Next slide. And so again, this slide just talks about the requirements on the employer to conduct COVID testing. The good faith belief would be like, does the person have manifest symptoms? For example, if they're conducting temperature checks, does the person have a temperature? Are they coughing? That is the sort of thing that will allow the employer to be able to conduct COVID tests. Next slide. And so that here, we've provided you a definition of what a direct threat is. It's a significant health or safety of the individual or others that can't be eliminated with a reasonable accommodation. And so again, that's critical in the context of COVID. Unlike tuberculosis, as we talked about in the Arlene case, what we do know is COVID is highly contagious, and and it can have deadly consequences. And so basically, per se, COVID does present a direct threat. Next slide. And so again, it's of interest to note that these 4 enumerated factors to consider are basically taken from that old case, Arlene. And so it's the duration, the nature, the severity, the likelihood of potential harm, and the imminence of the potential harm. Next slide. I've already discussed this. We can advance to the next slide. And so let me do a slowdown here. Again, I know my time is limited. You still must engage in the interactive process, even though the person may present a direct threat. If the person can otherwise perform the essential functions of the job, you have to do that slowdown. You have to engage in that interactive process. What we've seen, at least even in my own agency, telework works. That's a viable option. And so other possible accommodations include leave, the ability to self-segregate somewhere in the office, wear masks, have hand sanitizer, etc. Next slide. You could advance that. You could advance that. And so what I did want to leave with, because that seems like what we're on the cusp of, is vaccinations. Everybody is waiting for that great day when there'll be a vaccination. And, I hope that day comes myself, but, the caution with respect to vaccinations, folks still have the ability to not have to take an employer mandated vaccination based upon a religious accommodation, which I'll skip over if you can advance to the next slide. But under the ADA, if taking the vaccination would impact their disability or have a negative consequence because of their disability, an employer cannot require the person to take a vaccination. However, the employee has to show that the vaccination wouldn't just be inconvenient, but really would add or aggravate their disability. If you could advance to the next slide. And so, again, just part of our ongoing guidance with respect to COVID, we're advocating and advising employers just overall to be as flexible as possible. Next slide. And so I think this is the concluding slide. We have a wealth of information at the EEOC, and I provided you some of our technical assistance. And we continue to update our guidance. I believe we've even updated our guidance as recently as the end of September. So I just would encourage you, as you have questions, how to maneuver through this period of time and advocate on behalf of your client, that you consult and look at our website. So I don't know if there's time for questions and answers or questions, and I'll try to answer if I can, but I'm available. Okay, I understand that there's no time. I'd like to thank you for your rapt attention, and I appreciate the opportunity. So thank you.